Hi, and welcome into our replay of the Waukesha Christmas Parade attack trial. We are picking up on day 10 as the court returns from lunch. The prosecution has said they are close to resting and passing the torch over to the third-party intervener for the defense. God help us all.
Back on the record. It is just after 1 p.m. Appearances are as they have been. I do want to make a very brief record regarding the jury view. I did have Madam Reporter take her steno machine and make or take a contemporaneous record of the little bit that was said while we were there. I can state for the record, and I also had Madam Clerk take some minutes. The court arrived at 11:44. The state arrived. The defendant arrived shortly thereafter. The parties were each given an opportunity to do a walk around before the jury came in. The defendant did that. And then I walked around as well with my clerk. And then we all were positioned in various locations within the garage. The belly chains and handcuffs were removed from Mr. Brooks. He did not have leg restraints on that I could see. And so when the jury was brought in, he was not in any of that. And then I instructed the jurors at that point, our civilian bailiff, Michael, was in the lead. I said, please come in, walk around the vehicle one time slowly with the jurors, and then exit. That is what they did. 2 videos were made. One was prior to anyone being in there. It was just the sheriff's department personnel, I should say prior to the parties being in there. And they took a video of the garage and then a walk around the vehicle that was provided to me at the conclusion. It was on a large type drive. And then I provided that to Mike Nyman and Zach Tremaine, who then provided that to the media. And then the second part where we all were in there and the jury came through, that was also captured on video. All of that was put on a flash drive and will be marked as Court's Exhibit 1, along with the docket entries Madam Clerk will make. And then, of course, if need be, if a transcript is ever needed, I did document a few things as we went through that process, so that there's that contemporaneous record as well. Any party feel the need to add to the record I just made from the state?
No, Your Honor. Thank you.
From you, sir?
Not to that, no.
Okay. Thank you then. All right. Then I know the jury is ready to be brought back out. I believe the state has additional witnesses.
We do, Your Honor, and I have another large poster board that I'd like to show with the next witness. So I don't know if you'd like us to put it up on the witness stand now before they come out, or
do we need the easel for that?
Yeah, we'll need the easel too.
All right, since there's no jury out, you can put that on the witness stand now.
Thank you.
Maybe put it facing backwards, and then that will be there for the next witness.
Sure, thank you.
All right, and then anything from you, sir?
In regards to this?
Any of the preliminary matters that you are asking the court to address?
Were my filings actually filed?
You're talking about from this morning?
Yes.
Have they been scanned in so that you can get the originals back? Is that what you're asking?
Yes.
I will ask Madam Clerk if that has happened.
They have.
All right.
It has.
Let me see. I think in our papers that we have been keeping, there might have been another filing from you. So whatever we have, they've all been entered into the record, and you're getting back as a courtesy those filings.
That was the one this morning, and then these are the 2 originals that I had not given back yet. There were 2 that I gave him immediately, like I scanned them in right away, and then gave them back. These are the 2 I'm still holding.
There was 2 other ones, so I have one from October 5, one from October 13, and then one from October 19. These, just so we're clear, sir, I'm providing these as a courtesy back to you because the clerk's office policy is once they're scanned in, they are destroyed because then what's in the electronic file is what's kept. They do not have the docket entries, though, because you requested the originals back. So I'll provide those to you. Okay. Then, with that, we'll have the jurors brought out.
Subject matter jurisdiction, Your Honor.
The court's declining to address that further. I stand by my written decision that was entered last week.
So we won't be proving it for the record?
I stand by my written decision that was entered last week, sir.
Judicial determination?
It is a judicial determination.
Listening to the police radio traffic prior to this witness's testimony really gives you a better picture of what he and the last witness are describing. If you have missed any of those videos, I will link them in the description section.
All rise for the jury.
Thank you, everyone. Please be seated. The state may call its next witness.
Thank you. The state will call Detective Justin Rowe.
Good afternoon, sir. If you would please make your way to the witness stand, which is to my right. When you get there, please remain standing. Raise your right hand. My clerk, Teresa, who's on my left, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir. Please have a seat. First thing I will ask you to do is to state your first and last names for the record and then spell each.
Justin, Justin, Rowe, Rowe.
Go ahead, your witness.
Thank you. Detective, how are you currently employed?
City of Waukesha Police Department.
Can you briefly describe for the jury your experience in law enforcement?
From 2003 to 2009, I was a security police officer with the United States Air Force. And then from 2009 to present, I've been a member of the Waukesha Police Department.
And your current rank is that of detective?
That's correct.
I'd like to direct your attention to the date of November 23, 2021. Were you on duty that day, sir?
Yes, I was.
Do you recall what your assignment was that day?
I was tasked with going to the Maple Avenue and Northwest Avenue area neighborhoods to search for items that may have been discarded by Darrell Brooks.
And were you alone in that task?
No, I was accompanied by a whole team of other detectives and investigators.
Before you traveled to the neighborhood, did you have a plan of action?
We did. We planned to begin at 338 Maple Avenue, which is where the vehicle was left prior to Darrell Brooks fleeing the scene south. So we had begun at that location and began to canvass our way south and west.
Were you present when any items were discovered that were relevant?
Yes, I was.
And just very briefly describe what those items were, sir.
Objection, leading.
Overruled the witness may answer.
Specialist Spakowitz and I were walking in the parking lot of 322 Maple Avenue, which is a large apartment complex, and we came across a right-footed sandal, a blue sandal, up against a fence area that separates the Dunbar neighborhood or street homes from the Maple Avenue apartment complex.
Are you aware of any other items that were recovered during this effort on that same day of November 23, 2021?
Yes, a short distance from that sandal, some other investigators did locate a sweatshirt and a left-footed blue sandal.
Now, in addition to looking for items, did you and other detectives attempt to obtain video from homeowners and businesses in the area?
Objection, leading.
Overruled as foundational. The witness may answer.
Yes, we did.
And do you recall obtaining a video from the school district?
Yes, we did.
And do you recall what building or buildings from the school district video was recovered from?
Objection leading.
Overruled. The witness may answer.
It's a building that's right on Maple Avenue. It's we refer to it as the School District of Waukesha. It's their administrative building, also known as the Lindholm Building.
And you obtained video from that location?
Yes, we did.
Did you also obtain video from homeowners on Dunbar?
Objection leading.
Overruled. The witness may answer.
Yes, we did.
Specifically 435 Dunbar?
Correct.
Objection leading.
Overruled. It's foundational. Sir, please wait until I rule on the objection. Thank you.
And how about Central Street or Road?
Yes, we did.
Did you have an opportunity to review those videos that were collected?
I did.
And did you see anything of significance to this investigation in any of those videos?
Objection speculative.
Overruled. The witness may answer.
Yes.
I'm going to show you an item that's been marked as exhibit number 131. Show it on your monitor first, okay? So let me know when it's up.
It's up.
All right, and we're going to just take it out of presentation. There we go. Okay.
What exhibit is it?
This is 131, Mr. Brooks. What do you know Exhibit 131 to contain, Detective Rowe?
This is a video that is taken from 425 Dunbar Avenue, which is the south side of Dunbar Avenue. And if you see on the near the upper left-hand corner, the northern intersection area, there is a red sort of blur near the bottom of a driveway right before the intersection. And that is going to be Darrell Brooks on that sidewalk, and he's going to cross the street.
Okay.
Hold on 1 minute. I'm just going to remind the jury it's up for the jury to determine what the facts are, not what any witness's opinion may be. You will ultimately need to decide who was in that video. Go ahead.
And I should ask a broader question. The exhibit itself, the whole exhibit, does it contain, do you know what's in Exhibit 131?
Yes, I do.
Does it contain more than one video, sir?
Objection leading.
Overruled. I'll allow it. The witness may answer.
I believe this is one video of it itself.
Sure, but the exhibit contains multiple videos and
Correct.
Objection.
still shots?
Yes.
Okay.
Objection noted. I'll overrule it. It's foundational. Go ahead.
What are you looking at right now, sir?
I'm looking at the beginning of the video of Dunbar Avenue.
Okay. Do you believe, well, strike that. I'm going to ask the assistant to play this video for you at your monitor, and then I'll ask you a question, okay?
Okay.
DA Opper is going to roll out all of these video clips they've been identifying once Detective Casey is called back to the stand.
Before you do that, for the record, how long of a clip is it?
I was just looking for that because we're now in a PowerPoint, Your Honor. I don't know that I can tell you exactly until we get to the end.
Looks like 9 minutes or something.
9 seconds and
Oh.
9.56 seconds, Your Honor.
All right. Thank you. Go ahead.
All right, so we're playing this for you, Detective Rowe. All right. Were you able to observe the video?
Yes.
And were you able to observe anything of significance to this investigation in the video?
Objection speculative at that point.
Overruled. The witness may answer.
Yes, it appears the defendant is crossing the street.
This exhibit, I'm sorry, are you aware of the other videos and pictures contained in Exhibit 131?
Yes.
Objection leading.
Overruled. The witness may answer. Once again, please wait till I rule on the objections.
Do you believe all of the videos and pictures in Exhibit 131 are true and accurate based off of the videos that were obtained from the homeowners and businesses that you testified to previously.
Yes.
Move to admit 131 and permission to publish, Your Honor.
Objection. Directly to video.
Your objection is noted. It is overruled. Exhibit 131 in its entirety is received. And did you ask for permission to publish?
I did.
Go ahead.
And for the record, Your Honor, this is a PowerPoint. What's being displayed at the moment is slide number 1.
Thank you. Go ahead.
Is it on the jury box? Okay. All right. Please play the video in slide 1.
Well, I guess I spoke too soon.
All right, the video has played completely, Your Honor. I'm going to ask to move to slide number 2.
Go ahead.
Do you see what's shown on slide number 2, Detective Rowe?
Yes.
Describe what we're seeing in slide 2.
Upper left-hand corner, you're going to see another still image of the original video, and then below that you're going to see a zoomed-in, cropped image of the figure that would be crossing the street.
Okay. Have you seen this video on other occasions, sir?
Yes,
And obviously the zoomed-in image is quite blurry.
absolutely.
Okay. When we played slide 1, were you able to make out any details about the person in slide 1 that was crossing the street?
Yes, it appeared the person had a red shirt.
Okay. All right, we're going to go to slide number 3, please. And you testified about receiving video from the school building at 222 Maple Avenue, is that right?
Objection leading.
Sustained as to the form of the question. Please rephrase.
What is shown on slide 3?
Slide 3 is a view towards the rear parking lot of the Lindholm building, or also known as the School District of Waukesha Administration Building.
And I'm going to request that we play the video in slide number 3, Your Honor, in its entirety.
Do you happen to know how many seconds?
5.97.
Thank you. Go ahead.
Objection, relevancy.
Overruled. You may play.
Oh, you'll see, Mr. Brooks.
Did it play? Yep. I'm sorry, I missed it. Okay, we'll go to slide, next slide. Lost track. We're on 4 or 5. Slide number 4. Going to slide number 4. All right, so again, the camera, or strike that. What are we seeing on slide 4?
So again, we're seeing a still shot of the previous video we just viewed, and then there's a zoom in function below that where it shows a cropped out photograph of a figure.
Okay. And you've seen this video yourself in person, sir?
Yes.
What do you recall about what you were able to observe about the figure or subject walking there behind the school?
Objection leading.
Overruled. The witness may answer.
The figure moves from right to left through the parking lot or north to south up until until it reaches the fence on the left side of the picture.
All right. Next slide, please. Do you recognize the image in slide number 5?
Yes.
Or is it 6? It's 5. Okay. Please tell us what you recognize this area to be.
This is also the Lindholm building. This is a camera that is deeper into the parking lot, which means that it will be a closer view of the previous video.
Okay. I'm going to ask that we play this clip, Your Honor, and for the record, it's a total of 20.81 seconds.
Go ahead.
Objection.
Your objection's noted. Go ahead and play.
Thank you. Please turn to the next slide. What do we see in slide number 6?
Upper left-hand corner is a still shot of the video, and below that is a screen capture of a figure in that photo.
Okay. Next slide, slide 7. So currently we're looking at a black screen, correct?
Yes.
Do you know what this video is going to show, sir?
Objection, speculative. He's black.
Overruled. The witness may answer if he's able.
Yes, it's another home security camera at 126 Central Avenue.
All right. It's a total of 20 seconds, 20.09 seconds. And we will play in its entirety, Your Honor. And with sound on this one, yes, thank you.
Excuse me.
All right, next slide, please. What do we see on this final slide, sir?
Upper left-hand corner is a still shot from the video, and the screen that's been cropped at the bottom is a image of the defendant.
All right. That completes Exhibit 131. Detective Rowe, based on these video clips that you obtained and the canvas that you and your team did in the neighborhood, were you able to put together a map basically tracking the travels of Darrell Brooks through the neighborhood that afternoon?
Objection, I don't consent to being called that name in this meeting.
The objections are noted. Overruled. The witness may answer.
Yes.
And I should include, do you know the location where Darrell Brooks was arrested?
Objection, I don't consent to being called that name. Speculative.
Overruled. The witness may answer.
Yes, I'm aware he was arrested on Elizabeth Street.
Okay. And are you aware of reports to other officers as far as citizens that had contact with Mr. Brooks in the area of Elizabeth Street?
Objection, I don't consent to being called that name.
Noted. The witness may answer.
Yes, I'm aware.
All right. Behind you, sir, is a large poster board that's facing backwards. I'm going to ask you to please assist me by putting that face forward on the easel behind you.
Can you please tilt that so that the court and Mr. Brooks can see as well?
Yes, and we're also going to put up the digital copy, Your Honor. I just wanted to...
Oh, okay. Then that's fine then.
Okay.
Thank you.
I'll have him work off the digital copy, but before you sit down, Detective Rowe,
Sure.
in the bottom right-hand corner of that poster board, there is a sticker. Do you see that?
Yes, it is.
Objection, leading.
Could you help us by telling us the exhibit number? I'm sorry.
That's okay. It's foundational. I'll allow the question to be asked. Go ahead and finish your question and answer.
What's the exhibit number, Detective Rowe?
130.
Okay.
Thank you.
Detective Rowe, do you believe that Exhibit 130 is an accurate summary of the travels and the contacts by Mr. Brooks on the evening of November 21, 2021?
Objection, I don't consent to being called that name.
Overruled. The witness may answer.
Yes.
Move to admit 130 and permission to publish, Your Honor.
Objection.
I'm sorry. I cut you off. What's the basis, if you have?
Relevancy.
All right. The objection is noted. It is overruled. Exhibit 130 is received. Permission to publish. An electronic copy is granted.
Thank you. All right. Detective Rowe, I know we're back out so we can see the whole map at this point. We will zoom in a moment, but the northern most event that's reflected on the map reads what?
Officer Schultz shoots that SUV at 4:39 p.m.
Okay. Do you know that to be accurate based on your knowledge of this investigation?
Objection leading.
Overruled. The witness may answer.
Yes.
And then there appears to be a red line from that point going south down the middle or right side of the map. Do you see where I'm referring to, sir?
Objection
Yes, I do.
leading.
Overruled. It's foundational. The witness may answer.
Yes, I do.
What does that red line from the star where we noted Officer Schultz fired, the red line going south, what does that represent, sir?
The solid red line is the route taken by vehicle.
Okay. And where did it go? What roads?
Objection leading.
Overruled. Go ahead and answer.
Vehicle traveled south on Northwest Avenue, made a left-hand turn to go east onto Prospect Court. Vehicle then drove behind some residences on Maple Avenue before coming to a rest in the driveway of 338 Maple.
Okay, I'm going to ask Ms. Gussie to please zoom in on that upper right-hand quadrant of the exhibit, please. And specifically the area of 338 Maple, please. Okay. So you said the vehicle traveled through the backyards off of Prospect Court, is that right?
Objection. Accident issue.
Sir, please wait until I rule on the objection. The objection is noted. It's overruled. Now you may answer.
Okay. Can you just, that's a touch screen in front of you, so just kind of point out the area that you're speaking of right now.
I'm sorry, could you repeat the question?
Yes. Using the touch screen, can you point out the path of the vehicle that you just were describing for us?
Objection leading.
Overruled. Go ahead.
And when it came down West Avenue, right?
Yes.
And what road did it turn onto?
Turned east onto Prospect Court.
And then when it turns off of Prospect Court, is that a road?
Objection leading.
I'm sorry, when it left Prospect. I'm sorry.
Sir, which question were you objecting to?
The last one.
About which way it turned? Or turning onto Prospect?
The way it was actually.
You know what? I don't even remember what it was, so I'll sustain it and ask the state to re-ask.
Okay, sure. At some point, did the vehicle leave Prospect Court?
Yes, it did.
When it did that, was it on a roadway?
No.
So the line you drew from south from Prospect Court represents what, sir?
Objection leading.
Overruled. The witness may answer.
Backyards?
On the far right corner of the map, do you see a blue dot in the same area we're talking about here?
Objection leading.
Overruled. The witness may answer.
Yes.
And what does that represent, please?
The camera at Les Paul School.
And what's the address of Les Paul School,
Objection.
if you know, or the street?
Overruled. The witness may answer.
I don't know the address, but it is right off Maple.
Okay. And you see just below that there's a yellow dot with the name Wauwatosa Officer Sailors. You see that?
I do.
Okay. Now, you've stopped drawing your line there, your yellow line over the red line. You see what I'm referring to?
Yes.
And in that area, I notice the line becomes dashed. Do you see that?
Yes.
Objection leading.
Overruled. The witness may answer. Again, please wait till I rule on the objection.
Yes.
Thank you.
What's the difference between the red solid line and the dashed line, sir?
The dashed line is the path that the defendant took on foot.
Okay. And do you see then, moving back to the left on the map, the two boxes in white depicting where the sandals were recovered?
Objection, leading.
Overruled. The witness may answer.
Yes.
Is that consistent with your recollection, sir?
Yes.
The dash line then moves, so there's two green X's, correct? You see where I'm referring to, sir?
Objection, leading.
Overruled. The witness may answer.
Yes.
And then the red dash line moves to the left or west from the second green X, correct?
Yes.
What's going on at this point, sir?
This is a point where the defendant is traversing through yards towards the west.
Okay. And did we just see the video of him crossing the street there on Dunbar?
Objection, leading.
Overruled.
Yes.
Move up a little, please, or more to the back. Yeah, there we go. Okay.
Clear the line, please, Madam Clerk. Thank you.
Is the Wyndham building on this map, sir?
Yes.
Could you point it out? Did we just see the two videos from those two cameras at the Wyndham building in the last exhibit, 131?
Objection, leading.
Overruled. The witness may answer.
Yes.
Okay. Keep going south on the map. What's the next event that's noted, sir?
Do you want? Can we clear?
Yeah, yes, clear. I'm sorry.
Thank
And
you.
maybe we can move further south on the map. Thank you.
So the first thing that I see is makes a phone call at 4:47 p.m. Dominic Capron at 417 Central Avenue.
Okay. Is that the location of Central Avenue, sir? I'm sorry, 417 Central Avenue?
Objection, leading.
Overruled. The witness may answer.
Yes, it is.
Okay. And are you aware of conversation also reported by Sean Backler at his residence on Central Avenue?
Yes.
Is his residence shown on the map, sir?
Yes.
Can you please circle these two conversations that you just identified for us?
Objection, leading.
Overruled. You may indicate on the map.
Okay. Now I see the dash line moving to the west again. Do you see that, sir?
Yes.
What's happening in this area, please?
Objection, speculative.
Overruled. The witness may answer.
This is the camera at 126 Central Avenue. Mr. Brooks is seen on camera moving to the west at 4:48 p.m.
Was that in Exhibit 131 that we just showed the jury?
Objection, leading.
Overruled. You may answer.
Yes.
Which video was that one? Do you remember?
Objection, leading.
Overruled. You may answer.
It was the, I believe it was the last video that we had watched prior to showing the map.
Okay. Now at this point the dash line ends. Is that right?
That's correct.
Why is that?
Objection, speculative.
I'll allow the witness to give his opinion.
Because we don't have any indication as to where or when Mr. Brooks crossed West Avenue to get to Elizabeth Street.
Are you aware that there was a reported contact between Mr. Brooks and a witness identified as Aaron Cordes?
Objection, leading.
Overruled. The witness may answer.
Yes, I'm aware.
And is that area where that meeting occurred depicted on this map?
Yes, it is.
Where did that meeting occur?
It happened just west of Northwest Avenue on Elizabeth Street.
And is Aries Industries shown on this map, sir?
Yes, it is.
Could you identify Aries Industries? Are you aware of video from that location showing person appearing to be Mr. Brooks approaching the front door lobby of the business?
Objection, I don't consent to being called that name.
Noted. The witness may answer.
Speculative.
Overruled. The witness may answer.
Yes.
Okay. And then finally, the last red X on the bottom left corner there, what does that depict, sir?
That depicts 553 Elizabeth Street, the location of arrest, which was at 5:14 p.m. And that is the residence of Daniel Ryder. And Mr. Brooks makes and receives a phone call at 5:03 to 5:05 p.m.
Do you believe this map is an accurate documentation of the investigation, again, as to the travel of Darrell Brooks this evening, on the evening of November 21?
Objection is speculative, and I don't consent to being called that name.
Your objections are noted. Overruled. The witness may answer.
I'm sorry, can you repeat the question?
Sure. Do you believe this map is an accurate summary of the travel and whereabouts of Darrell Brooks at various points on the evening of November 21?
Objection is speculative, and I don't consent to being called that name.
Your objections are noted. They are overruled. The witness may answer.
Yes.
All right. Thank you, Detective. I don't have any other questions.
Any cross-exam for this witness, sir?
Yep.
All right. Thank you. Begin when you're ready.
So, Officer Rowe, you repeatedly referred to the alleged defendant's name. How did you come into that information?
Based on the entirety of the investigation.
And when did you come into the knowledge of the alleged defendant's name?
I don't remember.
When did your part of the investigation start?
After he drove the SUV through the parade, I was called at home to come in and help the departments with the investigation.
And just so we clear for the record, is the jury asking you questions or me?
What a smart ass.
I'm sorry, I did not hear the question. Repeat your question, please.
Well, I was referring to when I ask a question, he turns towards the jury as if they're the ones asking the question.
That's not a question, Your Honor.
It is a question.
We did ask a question about that.
Yes.
I think you're asking why does he do that? To that extent, the witness may answer.
I'm here to present the case to the jury.
So, I follow that fundamentally. But for the sake of making sure you hear the questions right, wouldn't it be fair to say that you should pay attention to the questions being answered, or being asked, rather?
Assumes the fact, not in evidence.
Sustained as to the form of the question. Please rephrase.
Wouldn't it make sense to focus on the questions so you can hear them clearly?
Objection argumentative still assumes the fact, not in evidence.
Sustained.
You made reference to you being here to present the case to the jury. So is that the reason why you decided to testify?
Objection to the relevance.
Grounds?
Overruled. The witness may answer.
I don't understand your question.
Were you able to hear my question clearly?
I don't understand your question.
Were you able to hear my question clearly?
Objection argumentative, Your Honor.
Sustained. Next question, please. Or rephrase the previous question to the one that was asked just now.
What was not understood about the question that you were asked?
Objection argumentative.
Grounds?
Sustained as to the form of the question. Please rephrase.
What wasn't clear about what I was asking?
Same objection, Your Honor.
Grounds?
It's the objection is sustained. Let's go back and ask the question that he says he didn't understand and rephrase it, please, or move on. Your choice.
Was your sole reason for testifying here today.
Objection, relevance.
Let's let Mr. Brooks get the question out.
Go apologize, I thought that was it.
Are you testifying today strictly to prove your case to the jury?
Objection, misstatement of his testimony.
Grounds that that's what he said.
Sustained as to the form of the question, misstates the prior testimony.
That's what he said. So why did you decide to testify here today?
Objection, that's a legally inaccurate question, Your Honor.
Please rephrase the question, sustaining the question asked as to the form of the question.
Nothing more dangerous than pompous and stupid combined in one mind.
I don't know how I'm supposed to rephrase that. Without having the same form of the question. That helps.
I'll rule if there's an objection, but ask a question, please.
Did you seek to testify here today in this matter?
No.
So how did you ultimately come to that decision?
Objection, that's a misstatement, Your Honor. It was not his decision.
Sustained as to the form of the question assumes a fact, not an evidence.
Were you subpoenaed?
Yes.
Do you recall by whom you were subpoenaed to testify?
District Attorney Sue Opper from the Waukesha County District Attorney's Office.
And at that time you were subpoenaed, you decided to testify.
I don't believe it's my decision.
Well, it would be fair to say that you didn't have to show up, right? That'd be fair to say?
No, I had to show up.
But would it be fair to say that you could have chosen not to?
No, it would not be fair to say that.
Exhibit 131 that was shown to you. Have you seen that video footage before today?
Yes, I have.
Do you recall who showed it to you before today?
I don't recall who showed it to me.
Would it be fair to say you've seen it multiple times before today?
Yes, I've seen it a number of times.
And do you recall when you were first shown that video?
Not off the top of my head.
Was it the same day of the incident, the days following, sometime after?
I don't recall when I saw the video the first time.
And what about Exhibit 130? Had you seen that video footage before today?
Objection, Your Honor. 130 is a map.
Or the map? Had you seen the map before today? I don't really think it's...
Just for the record, I'll sustain the objection just because it referenced the wrong number, but I believe you rephrased. So go ahead, the witness may answer.
Can you ask the question again, please?
Had you seen the map of Exhibit 130 before today?
Yes, I have.
Multiple times as well?
Yes, numerous times.
Any idea why you viewed it so many times, multiple times?
Unsure.
Were you able to obtain any more information upon seeing the map numerous times that you didn't obtain when first seeing the map?
No.
So it would be fair to say you pretty much knew what the map was detailing each and every time you saw it.
Yes.
And on that map, Exhibit 130, you made reference to at some point the dotted line, and it stops at some point. That'd be fair to say?
Could you be more specific?
The dotted line that was referred to on the map.
Do you want the map brought up? Would that be helpful to you?
Maybe it might be helpful to him.
He's got the large map, but if you want to...
So, if you can see the dotted line on the map behind you,
Yes.
is it fair to say that the dotted line stops at some point? Around Central Avenue, maybe?
Yes, there's a couple lines that seem to come to Central Avenue or egress out of Central Avenue that do stop.
And you stated that, well, what was the reason that you stated that line stops, the dotted line?
I stated that it's because we don't know the exact location where you cross the street to get over to Elizabeth Street.
And were there no cameras present at that point, or how did you lose the path of travel at that point?
We didn't find any cameras or any eyewitnesses in that area.
So it would be fair to say at that point you weren't sure what happened.
I know that you crossed the street at some point. We just don't know where.
How do you know that?
Because you were arrested on Elizabeth Street.
Did you see any crossing of, I think you said that was West? Would that be West Avenue that you were referring to, that you don't see any crossing of?
What's your question?
Is that West Avenue that you stated that you didn't see any crossing of?
That is Northwest Avenue.
Or Northwest Avenue, I'm sorry, I don't know the streets. Northwest Avenue. And you don't have any visual footage or any eyewitnesses, as you said, to say for sure if Northwest Avenue was crossed.
We didn't obtain any witness statements or any eyewitness or any video of the suspect crossing the street.
Do you guys think the prosecution warned these witnesses to brace for stupid, irrelevant questioning before they got on the stand?
And what day were you doing your part of the investigation? Was that the same evening or the next few days after the incident, or?
Can you clarify which investigation you're talking about?
The one that you took part in. Your part of the investigation.
I don't understand what time frame you're asking for.
What day did you start your part of the investigation?
Well, we started the investigation as soon as he ran people over in the parade.
And you were there?
I responded to the parade after he had done that.
Were you at the parade?
No, I was not.
So it'd be fair to say you were on call?
No, I was not.
So it'd be fair to say you don't know when your part of the investigation started then, right?
It would not be fair to say that.
You don't recall what time it was when you started your part of the investigation?
As soon as I responded.
And you don't recall when you were dispatched to respond?
It's in my report. I don't remember the time exactly, but it's in my report.
And at that time, did you know the identity or name of any alleged suspects at that time that you were dispatched?
The time that I was sent to the city of Waukesha, I did not know the identity of the suspect.
You made reference to a report. Do you recall when you wrote that report, or did you write the report yourself?
Yes, I typically type my own reports.
And do you recall when you submitted that report?
I have no idea what day I submitted the report.
Just once, I want to hear an officer answer that question with, "No, I have a ghostwriter who handles my reports."
So when you were first dispatched, what did you do?
I drove to the city of Waukesha and met with members at the Waukesha Police Command Unit.
And were you dispatched to any location from that point?
I was not dispatched.
Were you sent to any location from that point?
I was assigned with taking a number of investigators with myself and walking the entire parade route, going from establishment to establishment, bar to bar, restaurant to restaurant, and obtaining phone numbers and names of people who were present at the parade and who had witnessed something and would be followed up with later by a member of the Detective Bureau.
So it would be fair to say you did some interviews at that time?
Yes.
Do you recall how many?
No.
And after conducting these interviews, what did you do?
I went home.
So at that time, after conducting your interviews and then going back to your home, did you have the name or ID of any suspects at that time?
Yes.
And whom were you told by?
I don't recall.
Do you recall who you submitted your typed report to?
I don't understand your question.
Do you recall who you submitted your typed police report to?
No.
I'm assuming your law enforcement agency doesn't type up reports and just leave them sitting on the desk. Would that be fair to say?
That'd be correct.
Any reason why you wouldn't recall who you gave your report to?
Well, it's electronically submitted.
And from there, does it have a specific sergeant or lieutenant or captain or someone that it goes to from that point? If you recall, or if you know?
I wouldn't know.
So it'd be fair to say once you type a report and submit it, you're not sure who sees it.
Correct.
Would you say it's fair that because of you not knowing who your report is submitted to, that your report could be altered in some kind of way? Especially being that you don't know who sees it?
Oh, for heaven's sakes.
The reports are done via PDF style reporting. It's protected by my username and my password. And when it's submitted, it's usually not altered unless I request it to be altered.
But it is fair to say that there's a possibility that it could be tampered with because you don't know for sure who all sees it.
It's entirely inaccurate.
How so?
My report is accurate. My report is the way that it was written, the way that I wrote it myself.
So you've had a chance to read your submitted report after you submitted it?
Yes.
And to the best of your knowledge, is exactly word for word as you remember typing it?
It is my report. It is what I typed, and it is accurate.
Word for word?
Yes.
Do you recall how many pages long the report was?
Objection, relevance.
Grounds.
Sustained. Not relevant. Please move on.
Shut it down, Sue.
Do you recall if the report was lengthy?
Objection, relevance.
Grounds.
Sustained. Next question, please.
Grounds for the sustain.
Relevance.
And you stated that you read the report after you submitted it. Do you know how long it was before you were able to see the report that you typed?
Objection, relevance.
Grounds.
Sustained.
Well, he already answered that.
Then I'll object as asked and answered, Your Honor.
Sustained.
That question wasn't answered, but okay. I see. Do you recall when you typed your report?
Objection, relevance.
Grounds.
Sustained. Not relevant.
How's that not relevant if he already answered that he typed a report?
Please continue, sir.
Grounds for the sustain.
Relevant.
He answered that he typed a report. So how's it not relevant if he recalls reading when he typed it?
Please continue, sir.
You got to be kidding me. Did you file any claim related to this matter?
No.
Do you know if anyone who did?
Did what?
Do you know of anyone who filed a claim in relation to this incident?
No.
Do you know who the plaintiff is in this incident?
Objection,
Grounds.
relevance.
You may answer that question. Go ahead.
Can you ask the question again?
Do you know who the plaintiff is in this incident?
Well, plaintiff would be the state of Wisconsin.
Is the state of Wisconsin a human being or an entity?
Objection,
Grounds.
argumentative.
Sustained on relevance grounds.
Have you ever had any interaction with the plaintiff in this incident?
Objection.
Grounds.
Relevant, legally inaccurate.
Grounds.
Sustained as to the form of the question.
Were you ever contacted by the plaintiff in this incident?
Same objection.
Grounds.
Sustained as to the form of the question.
Would you call the state of Wisconsin a living, breathing human being? Or
Asked and
entity?
answered.
Grounds, because I didn't ask that question.
It's not relevant. Sustained. Next question.
It's very relevant. Seems like there's no plaintiff.
Jury will disregard statements made by the attorneys and the parties. They are not evidence. Please
Stop trying
ask
to
the
be
question.
So to your knowledge, the plaintiff is the state of Wisconsin. Do you see him present in the courtroom today?
Objection, irrelevant.
Sustained.
Can you identify the plaintiff state of Wisconsin?
Same objection.
Grounds.
Sustained. Sir, please continue and not on this topic. Next question, please.
To the best of your knowledge, you're not even sure if you've ever even had any interaction with the plaintiff state of Wisconsin, correct?
Objection, argumentative, and compound.
Grounds.
Sustained.
Definitely wasn't compound. Would you consider yourself an injured party in this incident?
Objection,
Grounds.
argumentative.
The witness may answer.
No.
Have you read or seen a complaint?
No.
No further questions.
All right. Thank you, sir. Any redirect?
No, thank you.
All right. Thank you, sir. You may step down.
Detective Rowe should be dismissed, please. And yes, could we get the exhibit?
Yeah, why don't you grab that exhibit and take it? That one has the exhibit sticker, correct? All right. We can keep it by the state for now, and then later on it can be brought over to the clerk. All right. The state may call its next witness.
It's going to call Patrolman Ryan Schultz.
Good afternoon, sir. If you would please make your way to the witness stand. When you get there, please remain standing. Raise your right hand, and my clerk, Teresa, who's on my left, will swear you in. Do we need this easel up?
This witness is a key part of the trial.
We're going to have to.
Yeah, or Detective Reglin can retrieve it.
Yes.
She's got to be great.
Thank you. All right. Thank you, sir. Please remain standing. Raise your right hand.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you, sir. Please have a seat.
He's basically ruling out any issues with the vehicle that could have prevented Brooks from controlling its motion.
First thing I will ask you to do is to state your first and last names for the record and then spell each.
Ryan Schultz, RyanSchultz.
Thank you. Go ahead, your witness.
Thank you. Sir, how are you employed?
I work for the Wisconsin State Patrol.
How long have you been in law enforcement?
I've been in law enforcement since 2014.
Have all those years been with the Wisconsin State Patrol?
Yes.
What is your current position?
My current position is the mechanical inspector for the Wisconsin State Patrol Technical Reconstruction Unit.
Can you describe the duties of that position?
Objection, relevancy.
Overrule. The witness may answer.
My job basically is to conduct thorough and systematic inspections of vehicles that have been involved in crashes. That can entail something as simple as taking photographs and looking at light bulbs to something more in depth, where actually take the vehicles apart and actually look at the moving parts of the vehicles.
Did you receive any training in order to perform those duties?
Objection, relevancy.
Overruled. The witness may answer.
Yes.
Can you briefly describe that training for the jury?
Objection, relevancy.
Overruled. The witness may answer.
A lot of the training that I received was on the job from prior inspectors. Prior to this, I was a diesel mechanic, and in addition to that, I have ASE and SAE certifications.
And not being having any interest in cars, what are those certifications?
Objection, leading.
Overruled. Foundational. The witness may answer.
SAE is for the electrical components in a car, basically, for the part that I am certified in. ASE is for the mechanical components, which stands for the Automotive Service Excellence, is what I believe it stands for.
What is the purpose of a mechanical inspection?
The purpose of a mechanical inspection is to determine if there was anything that was incorrect, defective, or broken on a vehicle prior to the crash that would have caused the vehicle itself to cause or contribute to the crash.
On December 6, 2021, were you directed to go to the Wisconsin State Crime Lab to view a vehicle?
Objection, leading.
Overruled. The witness may answer. It's foundational. Go ahead.
Yes.
What information did you have prior to going to that location?
Objection, speculative.
Overruled. The witness may answer.
The information that I was given is that I was to set up an appointment there to look at a Ford Escape that had been involved in a crash in the parade in Waukesha.
Did you go to that location on that date?
Yes, I did.
Did you do a mechanical inspection of the vehicle that you were sent to look at?
Objection, leading.
Overruled. The witness may answer.
Yes, I did.
After performing your inspection, did you draft a report?
Yes, I did.
And did that report contain the findings of your mechanical inspection from December 6th?
Objection, leading.
Overruled. The witness may answer.
Yes.
I provided to you prior to you going up on the stand what's been marked as State's Exhibit 83. Do you have that in front of you?
Yes.
Can you briefly identify it for how it's labeled, how many pages it consists of?
What exhibit is that?
Exhibit 83.
It's the Crash Reconstruction Mechanical Inspection Report.
The whole report is exhibit 83?
Correct.
Yes.
The whole report?
Go ahead. I haven't ruled on it yet, so go ahead and ask your questions, Attorney Daisy.
Sir, how many pages does this report consist of?
10.
And that is front and back sides?
Correct.
Objection.
Overruled. The witness may answer.
And on the face sheet of Exhibit 83, what information does it contain on that as it relates to this investigation?
At the top, it contains case number and recon number, which match my name, the reconstructionist, and then it begins the report and vehicle identification information, and then on the bottom it's marked with exhibit number 83.
What car were you inspecting?
Objection, leading.
Overruled. The witness may answer.
2010 Ford Escape.
And what color was it?
Objection, leading.
Overruled. You may answer.
Red.
And the license plate number associated with that vehicle?
A. Adam, D. David, P. Paul, 9256.
And on the report, the vehicle identification number on Exhibit 83, where did that information come from?
The vehicle identification number I verify on the inside of the door jamb of the vehicle. There's two VINs on each vehicle. One's a public VIN under the windshield, and one is inside the door jamb of the vehicle. I always use the one inside the door jamb of the vehicle first, take note of it, and then cross-reference it with the public VIN on the vehicle to make sure that they both match.
And did they in this case?
Objection. I have the 10 pages, and nowhere on here does it say it's an exhibit. Nowhere on here.
That's because it was marked for purposes of trial. It has an exhibit sticker now. So your objection's noted. It's overruled, and
Why am I not privy to the same?
the witness may answer the question. It's been marked as an exhibit. Go ahead, sir.
Can you restate the question? I forgot what it was.
I think I did too, but let's go with this one. Is the VIN number that you saw on the door, you said that you cross-referenced it with the VIN number, public VIN number. Did you do that in this case?
Yes.
And did they match?
Yes.
Does it give a drivetrain description on that first page or front page?
Yes, it does.
And first of all, I don't know what that means, but what is that?
Objection, leading.
Overruled. The witness may answer.
Drivetrain description describes the drive of the vehicle, basically how it's operated on the roadway. So in this case, it's an automatic transmission. It doesn't have a clutch. You don't have to shift the gears, and it's front wheel drive, meaning that it's not all wheel drive or rear wheel drive like a pickup truck. It's just front wheel drive.
And is there a picture on the front of Exhibit 83?
Yes.
Objection, leading.
Overruled. The witness may answer. Just a reminder to wait until I've ruled on any objection. Thank you.
Yes.
And what is that picture of?
It's a picture of the 2010 Escape.
That you did the mechanical inspection on?
Objection, leading.
Overruled. The witness may answer.
Yes.
Have you authored this report?
I did.
Have you had a chance to review it since you've authored it?
Yes.
Is the information contained within this report accurate?
Objection, leading.
Overruled. The witness may answer.
Yes, it is.
I would move State's Exhibit 83 into evidence.
Objection.
Your objection's noted. It is overruled. Exhibit 83 is received.
So is my paperwork ever going to say Exhibit 83, or is it just going to be this?
Mr. Brooks, I'll take that up outside the presence of the jury later, but we're going to continue.
It was brought up in front of the jury.
Mr. Brooks, we're going to continue with the questioning of this witness.
What are y'all trying to pull?
Mr. Brooks, please. No one's... The exhibit, to my understanding, has previously been provided to you. You have it. It's now been marked as an exhibit for trial purposes.
Y'all got something I don't have, though.
Go ahead.
That's not how it's supposed to work. It's supposed to be fair.
Attorney Basie, I trust that this was previously turned over.
It was, and I believe the defendant has a copy of it in front of him.
Thank
And
you.
where does it
Please
say
continue.
Exhibit 83? It doesn't say that this was going to
Again,
be
we'll take
used
this
as
up
an
outside
exhibit.
the presence of the jury later. It's not something we need to do right now. Go ahead and ask your questions.
Thank you, Your Honor. And I would object and move to strike from the record any commentary that the defendant was making in the last 5 minutes.
What was that?
Court will strike the commentary that was made. I'm not sure if it was picked up or not, but as a reminder to the jurors, the statements made by parties and lawyers are not evidence. The testimony and other evidence that's received is the evidence the jury will ultimately consider. Go ahead.
Thank you. Sir, can you briefly describe the condition of the vehicle when you inspected it on December 6th?
Yeah, the vehicle had quite a bit of front end damage. The bumper cover was pushed back, the grille was pushed back into the engine bay and into the radiator. That was also pushed backwards in towards the engine. The hood was folded up in the air. Both lights were broken out of the front. There was quite a bit of debris and unknown things stuck to the exterior of the vehicle, and there was also some damage to the sides of the vehicle.
Do you know why you had to go to the Wisconsin State Crime Lab in order to do the inspection?
Objection leading.
Overruled. The witness may answer.
I was requested to go to the State Crime Lab to do the inspection because they had not yet completed DNA sampling, so until they had it finished, it was going to be retained inside the crime lab. So in the interest of not moving the vehicle again, once they were done with DNA, they had me come to the crime lab to do the testing and inspection.
So the first section of your report, and I'm just going to direct your attention to page 3 of Exhibit 83, talks about the tires and the suspension and tie rods. Do you see that?
Objection leading.
Overruled. The witness may answer.
Yes.
And can you describe for the jury what part of the inspection, describe this part of the inspection?
Objection leading.
Overruled. The witness may answer. The report's been received by the court, and the state may direct the witness to various points at its discretion.
When was it made an exhibit? Because I wasn't aware of that.
Go ahead, Attorney Basie. You may continue.
Thank you. Sir, can you describe the information contained in the first section of the report under the heading Tires, Wheels, Steering, Suspension, Brakes?
Objection leading.
Overruled. The witness may answer.
So under this section, it's broken down into 4 parts. One for axle 1 left, which is the driver's side front axle. The left side would refer to it as you're sitting in the vehicle facing forward. The right side would refer to the passenger side. So axle 1 is the frontmost axle. Axle 2 is the rearmost, left and right, and it breaks each individual wheel end component systems down. And then from that, I take each one apart and inspect them thoroughly: brakes, tires, steering components on the front axle, obviously, suspension condition, and anything else that's at the wheel end that I can inspect.
And did you do that in this case?
Yes.
What observations did you make?
First, on axle 1 left, which would be the driver's side front, the tie rod end was worn. About 1/8 of an inch of play in the tie rod end, in the ball joint itself. So when you turn the steering wheel or turn the wheel, there was a little bit of play in the tie rod. Still attached, still intact, still functioning, still able to steer the vehicle, but just worn to the point that it needed replacement before it got any worse.
Was that something that would create any problems in operating the car, for example, on November 21st, 2021?
Objection speculative.
Overruled. This witness may answer. Hold on. He's been qualified under 907-02. I direct your attention to 907-02 through 907-07, Mr. Brooks. Go ahead.
I don't consider the vehicle that name, and that's referring to a specific date. How do we know that's not speculation?
The objection's noted. It's overruled. The witness may answer.
It would not. The vehicle would still steer and drive just the same as any other vehicle. It would just have play in the steering wheel, and it would make a little bit of a clunking noise potentially when you turn the wheel. You would maybe hear a clunking noise from that left front tie rod.
But again, operationally, the person driving that car wouldn't have any trouble steering based upon that issue?
Not at all.
Okay. What other observations did you make?
Other observations I made were that all the tires were evenly worn on all 4 axle ends. I believe it was the left rear axle, the tire on that axle was bigger than the other 3. So there's also a chart referenced later in my report that shows the difference between the two. The tires that are recommended to be on the vehicle are size 235/70 R16, which was what was equipped on the vehicle, except on the left rear, which was 245/75 R16, which is one full size bigger in dimension and aspect ratio.
What, if any, impact would that have on how a person's ability to drive that vehicle?
So one size bigger in tire is usually not the end of the world, being that it's the single tire. It can have an effect, but it's on the rear of the vehicle. Being a front-wheel drive vehicle, the speeds are reported off of the front axle of that vehicle. So that's where the speedometer would get its speeds from. The only time it would be notable would be during a heavy ABS brake application, and that would be at a higher rate of speed with full brake application where the ABS system kicks in on the vehicle. That's where it could be noticeable, and by could be, I mean the sizes are very similar. They're about 1.5 inches in difference. Revolutions per mile are not that far apart. The ABS system might not even pick up a difference between the two.
When you say at higher speeds, are we talking, what are we talking?
Higher
Overrule, the witness may answer.
Higher speeds, I mean something like highway speeds, 55 miles an hour, 70 miles an hour or greater.
Any other observations made with regard to in that area?
The only other observations that I made were that all the brakes were in good working condition and had adequate thickness left on the brake pads for stopping of the vehicle. All 4 brakes were in good working shape and they were able to be locked at the time of inspection.
So, and let me clarify if I didn't ask you this. The information you were provided was that this vehicle was involved in a crash?
Objection. Asked and answered.
Overruled, given the nature of the testimony being provided. The state may clarify that. So go ahead, you may answer.
Yes.
And do you know the date of that crash?
I know it was in November. I don't know the exact date.
Thank you. So with regards to the braking system, was there anything, did you find anything at all in your inspection of that vehicle that would have caused the brakes not to work or not to work effectively on the date of the crash or prior to the crash?
Objection. Speculative.
Overruled, the witness may answer.
No, I did not.
Actually, since your inspection took place after the crash, would that be your same answer with regard to, as it was on December 6, 2021, there were no brake problems?
Objection. Speculative.
Overruled, the witness may answer.
That is correct. The brakes still functioned at the time of inspection fully.
What was the next area that you then inspected?
The next area that I inspected was the electronic system and general cabin system of the vehicle, cabin being where the occupants sit inside of the vehicle. I did that by examining light bulbs on the exterior of the vehicle and then systematically working my way into the vehicle where I could.
What observations did you make in that area?
Both headlights were, the lenses were damaged, but the lights were still working. The lights were in the high beam position and in the automatic position from the driver's cabin.
What does that indicate?
Objection. Leading.
Overruled, the witness may answer.
So that indicates that when the vehicle was left at the last time, that the vehicle headlights were in the automatic position, meaning that if it's dark enough out, that the headlights would turn themselves on, and the selector stick was in the high beam position, meaning that the last time the lights were in use, they were in high beam mode.
Thank you. Continue on.
From there, just examine the throttle linkage, horn, and the other driver controls from inside the cabin.
So let's talk about the throttle controls. First of all, what is that?
So
Objection.
Overruled, the witness may answer.
everyone's familiar with the throttle pedal in the vehicle. You press the pedal, and it makes the vehicle accelerate. From there, on this specific vehicle, it's an electronic signal that is transferred from the throttle pedal to the throttle body on the vehicle's engine on the intake. That electrical signal opens a butterfly valve, which allows more air and fuel into the engine, speeds the engine up. If you let off the throttle, it reduces and closes that valve. On this particular vehicle, I checked the throttle pedal first inside the cab. It was free moving, no binding, no obstructions. I was able to smoothly press it to the floor and release it, and it acted just as it should. From there, I went under the hood of the vehicle. On this particular vehicle, the crime lab asked that I did not open the hood just because of the amount of DNA evidence on the front of the vehicle. They didn't want me to come in contact with anything, so they asked that I not open the hood if at all possible, which on this vehicle, I was able to still access the throttle because of the way the hood was bent up in the air. I was able to actually reach in from the side of the vehicle and access the throttle body components through the damaged hood portion where I normally would not have been able to reach. From there, I was able to look at the exterior of the throttle, and everything was in clean, clear working condition, no visible damage, no visible issues. I removed the intake tubing from the engine and inspected the actual throttle plate itself, which was in the closed position. Closed position indicates either an idle or that the vehicle is turned off. I was able to then actuate the butterfly valve itself from fully closed to fully open, and when I released it, it went back to fully closed just as designed by Ford.
Did there appear to be any problems with the throttle?
No, there was not.
I'm just gonna, I know you call it a throttle, I call it a gas pedal. It's one and the same, correct?
Objection leading.
Sustained as to the form of the question. Please rephrase.
What is the difference between a gas pedal and a throttle?
Nothing.
Thank you. What was your next area?
The next area I went on to was the seat belts inside the vehicle. And then from there, I actually was able to test the vehicle for function.
Did you then come to a conclusion section of your report?
I did.
And is that starting on page 5 of 10?
Yes.
Okay. Did you check the power steering system?
I did.
And what observations did you make of that?
Aside from the ball joint that was loose that I described earlier, the entire rest of the power steering system was intact and functioning properly.
So there are no problems that would cause the car not to steer appropriately?
Objection leading.
Sustained as to the form of the question. Please rephrase.
Did you observe any problems with regard to the steering?
Aside from the ball joint, no.
Thank you. Now, in your report, you indicate a gross vehicle weight rating. Do you see that on page 5 of 10?
Objection relevancy.
Overruled. The witness may answer.
Yes, I do.
What is that?
The gross vehicle weight rating is the amount of weight that the vehicle can physically carry safely, and that number is administered by the manufacturer.
So that includes people within that car? Is that what you're saying?
Objection speculative.
Overruled. The witness may answer based upon his training and experience.
Yes, that would include all the vehicle weight, occupants, and cargo.
And the curb weight, what is that? I mean, generally, what is it now?
Objection leading.
Overruled. The witness may answer based upon his training and experience.
The curb weight of the vehicle is the weight of the vehicle as it rolls off the floor at the assembly plant, and that's without fuel and coolant and oil and things like that, and it's a dry weight of the vehicle. It's what the vehicle itself, with nothing in it, physically weighs.
Thank you. If someone had reported hearing a clicking sound while this car was driving in front of them. Was there anything that you found in your report that would be consistent with a clicking sound being heard?
Objection, hearsay.
Overruled. The witness may answer.
There was a lot of damage to the front of the vehicle. It would be impossible to say what a clicking noise could come from, being as there's a lot of moving components under the hood with belt pulley, the engine fan, things like that. Anything could be stuck in a tire. It would be impossible to say if there would be a clicking noise from this vehicle. I was actually not able to drive it physically to test it. I was only able to just start it.
Can I ask why you were unable to drive it?
Objection, relevancy.
Overruled. The witness may answer.
There's actually two reasons I was unable to drive it. One, again, with DNA evidence on the exterior of the vehicle. Two, there wasn't enough gas in the vehicle to move it.
Okay. So the car was on empty when you observed it?
Objection, leading.
Sustained as to the form of the question.
How much gas was in the car when you inspected it?
Objection, leading. Answer.
Overruled. The witness may answer.
There was, the gauge read E for empty, and the notation on the infotainment center originally said 2 miles to empty, and then on the second key cycle it said 1 mile to empty.
When you said key cycle, when you started it, when you turned the key, what observations, if any, did you make?
Objection, leading.
Overruled. The witness may answer.
So when I tried to start the vehicle, it was very sluggish. It turned over, but it wouldn't fire, it wouldn't do anything. And then it made like a hiccup sound, like it was going to try to start, mimicking basically a vehicle that's out of fuel. And when I tried turning the key again, then the vehicle actually did start, did idle, and did run like it was supposed to. That's when I saw that the fuel gauge, the distance to empty gauge, went from 2 miles to 1 mile, indicating that the vehicle was very much so out of fuel almost. And I recorded this with my camera, and I tapped the throttle to do a rev test on the engine. The engine revved and went back to an idle. When it went back to an idle the second time, it then sputtered and turned off.
Which would indicate what?
It would indicate that it's not getting enough fuel to run correctly.
Thank you. Now, if a witness had testified that when the vehicle went in front of them, they heard a high-pitched, like a revving sound, based upon your examination, what would that be consistent with?
Objection, hearsay.
Overruled. The witness may answer.
There's a lot of different things that could cause that. It could be heavy acceleration from someone pressing the throttle on the vehicle. It could be noise that is amplified because the engine bay is now open to the exterior, so you can hear the engine noises coming from the engine bay of the vehicle. It could be an exhaust-related item. It could be a lot of different things, to be honest.
When you were doing an examination of the undercarriage of the vehicle, did you observe a muffler?
No, I did not.
I want to show you what's been previously admitted, Exhibit 73. It'll show on the screen in front of you, and I'd ask that it be published as well.
Objection, leading.
Overruled. Permission to publish 73.
Sir, do you see the picture that's marked Exhibit 73? It's not actually marked, but it is Exhibit 73.
I do.
What is depicted in that photograph?
Objection, speculative.
Overruled based on his training and experience. The witness may answer.
That it appears to be an exhaust muffler and a couple chunks of wood and overturned dirt.
The muffler that's observed in this picture, would that be consistent or inconsistent with a 2010 Ford Escape?
Objection, speculative.
Overruled. This witness may answer and provide an opinion. Go ahead.
By just looking at a picture.
Overruled. The witness may answer.
Y'all think y'all...
You can cross-examine the witness about that, sir.
I
Go
don't
ahead.
got to. Y'all trying to pull a fast one.
It is a vehicle muffler. Without seeing the ends of it and where the inlet, outlet are, and actual measurements, it would be impossible to say what vehicle it came from, but it is an automotive muffler.
And sir, at the end of your inspection, do you come to a conclusion with regard to the mechanical fitness of this vehicle?
I do.
And what was that conclusion?
My conclusion was that the tie rod on the left front end of the vehicle that's responsible for steering, the joint was worn and had been worn prior to the crash. This is not something that just happens immediately or overnight. If it would have been due to crash damage that this was damaged, I would expect to have seen a lot more impact in that area with bent metal or distorted items. The tie rods are very tough parts, so that to me indicates that it was worn prior to the crash occurring, and the tire, obviously, unless somebody changed it in between the crash occurring in my inspection, the tire was a different size than the other three prior to the crash, and it had been driven like that. I did not see any issues from the tie rod affecting steering as far as it relates to the alignment of the vehicle. Once things are worn and they start to get excessively worn, they manifest themselves in incorrect tire wear. Tire might chop or feather. That was not present on this vehicle. Had the left rear tire been an issue on the vehicle, I would have expected to see that manifest itself in an ABS, which is an anti-lock brake system failure or a trouble code in the vehicle. When I ran the vehicle and with the key in the ignition in the on position, there were no diagnostic trouble codes present on this vehicle indicating any issue whatsoever.
And two things that I guess I need to cover. Do you check to see if there are any recalls of a vehicle in coming to your conclusion?
Objection, speculative, and do we still need this exhibit?
Oh, thank you. We can take that down, and your objection is noted. It's overruled. The witness may answer.
I do check for recalls, yes.
Were there any on this vehicle?
There were not recalls on this vehicle. There was only an extended service warranty from Ford, which had since elapsed due to the mileage on the vehicle.
Now, you talked about the brake system in terms of the brake pedal within the car and its that it was operating correctly. Do you recall that testimony?
Objection, leading.
Overruled. It's foundational. The witness may answer.
Yes, I do.
Now, when a person activates that brake pedal, what is happening within the car?
There's actually a lot of things that happen within the car when you activate the brake pedal. When you press the brake pedal, it pushes on it's called a push rod, but it actually pulls on it. It pulls on the rod, which goes into the brake master cylinder, and that master cylinder is what pumps hydraulic fluid from the brake fluid reservoir to each independent wheel. On this vehicle, it's equipped with anti-lock brakes. It goes through an ABS modulator first. From there, it sends a signal to stop or slow down, depending on the amount of pressure that you apply inside the cab. Depends on how much braking force you get at the wheel ends. In a very heavy brake application, as I had discussed before, where the vehicle is still trying to maintain momentum, the ABS system can override, and that's where you would get the vibration in the pedal that many of you may have felt before. That's your ABS system doing its job, not allowing the wheels to lock themselves up. What it's actually doing is pulsating the fluid in the vehicle.
And when you talk about brake pads, how do the brake pads, where are they located, and how do they relate to the pressing down of a brake pedal?
Objection, leading.
Overruled. The witness may answer.
So when the brake fluid reaches each wheel end, there's a set of calipers with pistons, and those pistons actually come out and they act like a clamp, and they squeeze the two brake pads together. They're located between the two sides of the piston and on the exterior of the brake rotor. And what that does is it creates a pinching motion, and that pinching motion slows the rotation of the disc down, which is the brake disc, which is attached to the wheel hub. And that's what slows the vehicle.
And just for the record, he was using his right hand to demonstrate kind of a squeezing motion. He had and I would describe his hand in a C motion, maybe 3 to 4 inches between the thumb and the fingers, and then pressing together a couple of inches.
Thank you. Are there any other components to the braking system in a car?
Objection, leading.
Overruled.
There's a parking brake system in the vehicle.
But other than that, so you've covered every aspect of the braking system in this particular vehicle, is that correct?
Objection, speculative.
Overruled. The witness may answer.
Yes, I have.
Did you observe anything at all that would have prohibited this vehicle from stopping if the brake pedal had been applied?
No.
There it is.
Is there anything that you observed or documented with it during or in your mechanical inspection report that would have contributed to the crashes that this car was involved in?
Objection. I say answer.
Overruled. The witness may answer.
No.
Thank you.
Good, thank you. Any cross-examination?
During your inspection, did you see any bullet holes?
Yes, I did.
Do you recall where? Back up. Do you recall how many bullet holes you observed?
I do not recall a number of them. No, I knew there were more than one.
What are bullet hose? Is that some type of new escort service?
The ones that you observed, do you recall where they were?
I do believe one might have exited through either the windshield or rear window, and one was in the side of the vehicle, if I remember correctly.
And did you find any shell casings?
No, I did not.
And you said you did the inspection on December 6th?
That's correct.
Do you know if the vehicle had been do you know if anyone attempted to start the vehicle in between that time of the crash and your inspection?
Not to my knowledge, no.
But you don't know for sure?
That's correct.
You made reference to the left rear tire being bigger than the other tires.
Yes.
Can you give a little bit more clarity on how that would affect the vehicle?
So one larger tire on the vehicle would obviously make the vehicle lean ever so slightly away from whichever side is larger than the other. In this case, the amount of difference between the two tires, it's about 1.5 inches in difference in radius. So in radius, you get half of that amount in height. So it would be about 3/4 of an inch difference in height. That amount of difference is not noticeable in a vehicle. The other thing that it would cause is premature tire wear from one side to the other over time, to where one tire might wear faster than the other. The suspension might not act correctly because it's not at the same ride height anymore. So eventually over time, those are things I would expect to potentially see from that. Each vehicle acts differently with different size tires on it. There's no one size fits all.
So different vehicles act differently to having a bigger fitting tire.
Yes.
You made reference to it to a vehicle leaning away from the side that's bigger.
Correct.
Would that in any way create a slight pull to the vehicle to either side?
In my experience, that small amount would not, no.
And you made reference to the high beams. I don't remember exactly what you said referring to the high beams. I guess you made reference to them being used at some point.
The high beams were activated when I did my inspection, meaning that when the headlights are on, they were in high beam mode. The selector stick was pressed forward for the high beams.
Why would a vehicle use high beams?
Usually a driver uses high beams to see better or to illuminate things better.
So that would primarily refer to if it was nighttime?
Correct.
Would you say, with your expertise, it wouldn't make sense for a vehicle to use high beams in the daytime?
There are limited uses for them in the daytime, yes.
And what are some of the uses from your knowledge?
Generally, the high beams shine brighter, so even with sunlight shining on them, other vehicles can see them. It's a thing that we use on the highway as law enforcement sometimes. We'll use the high beams at a crash scene. We'll turn the high beams on so oncoming traffic coming in during the daytime sees that brighter light from the vehicle. It's just a little bit of the thing to help oncoming vehicles see.
So it would essentially be for identification purposes?
Not so much for identification, no.
Well, what do you mean when you refer to for oncoming traffic to be able to?
More for visibility is what I mean, so that it stands out to the other traffic. It doesn't look like it belongs because the lights look very bright. It gets the other driver's attention, the same as the red and blue lights on the top of the cars.
It gets them to notice that law enforcement is present.
Correct.
That's what I meant by ID purpose, for them to be able to see.
Then yes.
Does someone need to remind Brooks he is cross-examining the witness, not conducting a podcast interview?
Were you able to inspect the entire engine?
I was not able to inspect the entire engine.
And what parts of the engine were you not able to inspect?
The only parts that I was unable to inspect would be down in the front by the belt pulleys area. I could see that the radiator was pushed into it, but I couldn't see what components had been damaged by that, as far as like water pump or anything like that. And I do not usually take the engines down, meaning I don't take them apart as part of my inspection anyways. My main under the hood inspection components would be non-engine related aside from the throttle.
You made reference to the water pump. Did you notice any water leaking?
Yes, there was coolant that had leaked from the vehicle.
From the water pump?
I don't know where it actually had leaked from, but I know that there was a lack of coolant in the vehicle. It could have come from a lot of various different places. It was no longer leaking when I saw it. It was empty.
So you didn't actually observe it leaking?
Correct.
So it'd be fair to say you don't know where the leaking came from?
That's correct.
Were you told that the vehicle was leaking?
No, it just has a low coolant level, meaning it leaked from someplace or it had never been filled properly.
So at that time, it'd be fair to say you weren't sure if it had been filled properly or if it was leaking?
Either is possible.
But it'd be fair to say you didn't know for sure which of the two?
Correct.
You made reference to a loose ball joint. Can you give a little bit more clarity on exactly what is a ball joint?
So the ball joint is at the wheel end. When you turn your steering wheel in your vehicle, there's a shaft attached to the wheel, goes down to a rack and pinion system. The pinion is a round gear. The rack is a flat piece of metal with gear teeth on it. As you turn, it pushes the tie rods left and right. As you turn left and right, On the end of each of those tie rods is a ball and socket joint, much like the hip joint on a human being. It's a ball that fits inside of a socket, and what that does is it allows the wheel to turn left and right as it's being pushed by the tie rod without any binding or any issues in between.
That is clarity. I don't know anything about cars, so. And you said there was a loose ball joint?
Yes, the left front was loose.
And to what effect could that affect the vehicle?
The amount that it was loose, it would only wear more with more use. As those components start to wear down, they start to have a little play. The longer the vehicle is operated without proper repairs, the worse the play gets. The worse the play gets, then you can start having issues with improper tire wear and so on and so forth until it gets to the point that it actually separates. The ball and socket themselves will separate from each other.
And then what happens at that point?
If the ball and socket joints separate, you would lose steering at that wheel. The other wheel would still be able to steer.
From your inspection, can you tell roughly how long this loose or this ball joint was loose?
I cannot tell exactly how long, no. I can say that it was loose before the crash occurred, just based on the fact that it was worn, not broken.
So with your expertise, would it be fair to say that needed to be taken care of?
Yes, that needed to be corrected.
And you made reference to the gas. The vehicle having difficulty starting. Would that be fair to say?
Yes.
And reference to the axles, you made reference to taking them off the vehicle?
The axle I do not take off of the vehicle at all.
What did you do in regards to the axle?
The axle ends, wheel ends, that's where the brake components are mounted. So I remove the wheel and tire from the actual axle end.
I think that's what I was referring to. Okay. I'm sorry if I misquoted. I know you made some reference to removing something. I just assumed you meant the axle. When you inspect the axle and remove, you said the wheel?
Yes.
What is being inspected at that point?
So when I remove the wheel and tire from the vehicle, I remove all four of them one at a time, and that's where I actually look at the brake components themselves, being the brake pads, the brake calipers, pistons inside the caliper, brake rotors, and then I get a better view of the tie rod that I was just speaking about because it's actually next to the wheel on the axle end of the vehicle.
You said the tire rod?
The tie rod ball joint that was loose.
Oh, okay. So I think you just were clear about the ball joint and tire rod. Is there a difference between the two?
Yes, the ball joint is the joint itself, and it's on the end of the tie rod.
Did you notice anything wrong with the tire rod? the actual tie rod, not the ball joint?
No, there was nothing wrong with the tie rod.
Just 1 second. I'm just looking over these notes.
Go ahead.
Knowing what he did to these people sitting in the gallery behind him, he has no problem making everyone wait on him while he preps for each witness while they are on the stand. And that is the part that just blows my mind. Like, I do not understand how someone could be so clueless to others. It's as if there is no parts of his brain and heart that impulsively knows or feels for another human being. The only time he shows remorse is when it is put in his face, and we know he is faking it. The big elephant in the room that everyone cannot stop looking at, and Brooks has no clue it's there.
On page 9 of your report, and you did give some clarity to this. I'm just curious to know, on page 9, well, first of all, you wrote this report yourself, correct?
Yes.
On page 9, the second sentence, I'm assuming you still have the exhibit 83?
Yes, sir.
It says, I noted a worn tie rod end on the left front wheel end. Was that in reference to the ball joint and not the tie rod?
Yes. They're one and the same. The tie rod end is a ball joint. It's two different ways to refer to the same component.
Okay, I was clarity. It doesn't say ball joint right here. Would that be fair to say?
Correct.
And what is the high mount brake lamp?
The high mount brake lamp is on the back of the vehicle. You have the right brake light and turn signal, left brake light and turn signal, and then there's the third brake light that's like usually in the rear window or at the top of the back of the hatch of the vehicle. That's the high mount brake lamp.
Okay. And it was inoperable when you inspected it?
That's correct. Both of those were inoperable during inspection.
So they didn't work?
Correct.
So it'd be fair to say if someone was viewing the vehicle from behind, they would be able to see because those were inoperable.
Yes, at the time of inspection, those lights did not work.
And you also stated that it is unknown if they were working prior to the crash or damaged during the crash. That'd be fair to say?
That's correct.
That you would know either way?
No, I would not have a way to tell when that light bulb went out.
No further questions.
Thank you. Any redirect? Before you do that, I'm just going to have my jury stand for a second. Go ahead. All right, thank you. Be seated. Go ahead.
So you testified on cross-examination that the right and high mount brake lamp were inoperable. Do you recall that?
Yes.
How about the left brake lamp? Was that operable or inoperable?
Objection. Leading.
Overruled. The witness may answer.
The left stop lamp was working.
Now, sir, just going back again to this ball joint, you stated that, I guess, was your testimony and cross-examination that unless the ball and socket is separated, you can still safely operate that vehicle?
Objection. Mischaracterizes what was said.
Based on the form of the question, I'll allow the witness to answer.
Yes.
And the ball and the socket on this vehicle, were they separated?
They were not.
Now, your inability to fully inspect the engine, I want to direct you to that area of the vehicle. Does the engine control acceleration?
Objection. Relevancy.
Overruled. The witness may answer.
No, it requires driver input.
Does the engine control braking?
No, it does not.
Does the engine control steering?
Objection. What is the relevancy?
Overruled. The witness may answer.
No, it does not.
Does the engine control gear shifting?
Objection. Relevancy.
Overruled. The witness may answer.
It does not.
Finally, sir, you had talked about actually coolant or some type of water. I wasn't sure if you're talking about the water pump or the radiator. Do you know what was leaking, if anything?
Objection. Asked and answered during cross.
Overruled. The witness may answer. It's redirect.
Yes, so water pump, water coolant, it's all interchangeable as far as the cooling system for the engine goes. And the coolant system was low at the time of inspection and had been leaking, but from where I do not know.
And again, does that control the steering,
No.
the braking,
No.
the acceleration?
No.
Finally, sir, you had talked about on cross-examination the presence of the high beams being on during the daylight. Do you recall that line of questioning?
Yes.
Specifically, you had indicated that sometimes the state patrol uses their high beams during the day. What was that for?
Objection. That was answered.
Overruled. The witness may answer. It's redirect.
To increase visibility.
Is that of any assistance if a vehicle is coming up behind people?
Objection. Speculative.
Based on his training and experience, I will allow him to answer.
No.
Thank you. Nothing further.
All right, thank you. You may step down. I will take that. Thank you, sir. And once the witness passes, I'll excuse the jury for an afternoon break. It's just about 3:06. We'll take about 15 minutes. I'll rise for the jury. You can be seated. Mr. Brooks, I know the last thing you said, I heard you say that's hilarious. What were you referring to?
I was referring to, like, are you serious? Some of the same things that I ask on when it's my time to question the witness can be overruled, but when the same thing is done and I object, it's nothing. It's just thrown. It's just thrown to the side. I just think that's funny.
Well, sir,
really do.
I don't find it funny, number one. Number two,
You're not in my position either.
The court rules on the objections at the time that the objections are made. I know, and I wanted to address this briefly. You can have a seat. You had questioned during the testimony of this witness, Exhibit 83, because I believe what you were saying is, and you can tell me if I'm wrong on this, the copy of the report you have does not have an exhibit sticker on it.
It don't.
Right. And
You want to see it?
I don't doubt that your copy does not have an exhibit sticker, because at the time the report was provided to you, and I'll have the state correct me if I'm wrong on this, it would have been provided through the course of discovery. I'd also note that on April, I believe, 22nd of 2022, the state filed a notice of expert naming Inspector Ryan Schultz as an expert witness and indicated that he would testify consistent with his report. And then I directed your attention to the statutes in the rules of evidence dealing with expert testimony, specifically starting at 907.02 through 907.07. That is why I didn't stop during the testimony to have a discussion outside the presence of the jury, because at that point, the objection to not having an exhibit sticker on your report is not would not prevent the court from receiving the exhibit once the proper foundation was laid, which in my opinion it was. And the fact that your document didn't have that specific exhibit sticker doesn't diminish the fact that I know from your cross-examination you were referring to the report. At times you referred to it by page number. It was clear from your questioning that you had reviewed it. I would just note two examples. You asked some questions regarding visibility and the impact of the high beams. That was one example. And then secondly, questioning him about the ball joint and whether it needed attention and what that would mean. And so I just wanted to make...
That didn't come from the report, Your Honor. The only thing that came from the report was from page 9, when I was trying to get clarity about why it said worn tie rod.
Oh, and you actually questioned the witness about the different tire and what that would mean. So I thought three good areas of cross-examination that you covered. As far as the other issues I think that you might have when there's redirect, I'm not going to explain what redirect is, sir, but again, for my position, there's direct examination, there's cross-examination. The state or any witness, any party that calls a witness always has the opportunity to ask the direct exam questions and then redirect based upon what's asked during cross-examination. Sometimes that does mean there's some repetition, but I didn't see anything through the redirect of this witness that I thought was improper. So I just wanted to make a record of that. I am going to caution you, sir.
Do you understand what I was saying?
But during multiple times during the questioning of that witness, you were mumbling under your breath. You say disparaging remarks toward the court, toward the witness, or toward the process.
So if it was disparaging, what did I say?
Sir, you say things like it's not fair, or you make noises that suggest like you're disgusted with the ruling that is made.
So you're assuming what I mean by that, and when did I say it
Mr. Brooks, I'm
fair?
just making a record because
Yeah, but
it's important
you're making an
that
incorrect record.
it's important that you demonstrate courtesy and decorum through these proceedings, and that you give respect to the witnesses who are testifying in the process.
Did the witness feel disrespected? Did the witness say anything about feeling disrespected?
Mr. Brooks, I'm not going to engage in this
I don't think
back
he did.
and forth with you because, first of all, it's a mischaracterization of my observations, number one. And
Yeah,
number
but your
two, it's
observations
my
are
job.
incorrect.
It's my job to ensure that under 906.11 that there's the effective presentation, and I'll just refer you to that once again. I'll read it into the record.
You don't need to read it.
Under
You don't need to
906.
read it. Just make sure
11,
that you make a correct
the judge shall exercise
record.
reasonable
Don't lie on the
control
record.
over the mode and order of interrogating witnesses and presenting evidence
it's gonna
so
get
as to do
addressed
all of
every
the
time.
following. Make the interrogation and presentation
Every time.
effective for the ascertainment of truth, avoid needless consumption of time, protect witnesses from harassment or undue embarrassment. Sub 2 talks about the scope of cross-examination. Sub 3 talks about leading questions, and when leading questions may be used to develop the witness's testimony. So with that, we'll take our break. I'll start the 15 minutes. It's 3:13. We are in recess. Thank you. Go ahead.
I did actually take note of when the court overruled one of Mr. Brooks' objections. His response was, "Stop trying to be slick."
Yeah, I did say that.
So, just for the record, I thought that was very disrespectful.
Thank you. I would agree.
Judge, can we discuss scheduling at some point as well, either now or on the
When we
return?
come back.
Why wasn't that addressed right when it happened?
Honestly, Mr. Brooks, we're really trying hard
Because
not to
that's
highlight
the definition of trying to be slick.
during the trial, and trying my best here to
I don't see
frankly
that.
minimize
I don't
pointing
see
those
it.
things out to the jury and instead
I
pointing
don't
them
see it.
out outside the presence of the jury. You may have noticed I've even started to say I'd remind the jurors that the comments of the parties or the attorneys are not evidence, so as to cast a broad brush and not simply highlight your conduct.
I haven't noticed anything, and I
But all right, we're in
refer
recess.
to what
Thank you.
conduct
It's
you're referring
3:14.
to. If you're gonna be biased, then somebody else.
That will do it for today's trial coverage. Now let's talk about why Brooks was out on bail. As I had said before, Darrell Brooks has been a career criminal since his teens. The most heartbreaking part of this entire story is that he should have never been out of jail to cause this rampage in November of 2021. I love the words spoken by the Waukesha Court Commissioner who oversaw the bail hearing for Brooks after the parade arrest.
We have a gentleman that has a huge background via multiple states. Just going through some of the Wisconsin cases, they're violent. We have substantial battery, DC, strangulation, suffocation, resisting. Pending cases, which the statute I just read references that I should consider: second degree reckless endangering safety while armed, felon in possession of a firearm. Attorney Opper told me that the gun apparently was a stolen handgun. Those are allegations. He's out on bail on that. Also out on bail on the Milwaukee case ending 4596, where he's charged with second degree reckless endangering safety, disorderly conduct and battery, and resisting. And then we get into Nevada. Battery, domestic violence, the sexual assault, the sex offender registration violation, and then the battery in Georgia. Other considerations are, on WCS, their report indicates level 4 monitoring, which is the highest level of monitoring that we have. And in that report, it does indicate there have been failures to appear other than 2 years old, and then sentenced to incarceration prior, yes. Current violent felony, yes, or offense, yes. Pending charges at the time of this offense, yes. Prior misdemeanor convictions, yes. Prior felony convictions, yes. Prior violent conduct or conviction, yes. Prior violent convictions, 3 or more. So there have been missed court dates, although none in the past 2 years, but then we just heard about a rather significant duration of a 6-month stay in Georgia, in custody there. Resisting, again, these are things that would cause me to feel that this gentleman does not follow rules very well. Orders of the court, orders of society, resisting an officer. There's a bail jump in 2012. There's a bail jump charged in the 4596 case. There is in the 2550 case, again, the felon in possession of a firearm. All those things are just societal, legal issues, also orders of the court in some instances that are not being followed. While out on bail on 2 rather significant allegations, we are now faced with 5 counts of first-degree intentional homicide. I believe you are a flight risk. There's failure to follow court orders. This allegation, although the motive is not known, and I'm not entitled to know what that is, but it looks like there was either panic or whatever, or an intentional act for whatever reason. You don't do well under pressure. The Milwaukee County case talks about, as Attorney Opper indicated, you using a vehicle to run over another person with your vehicle. So you don't respond well to what is common sense within our community, our society. I'm an old guy who has been doing this for almost 40 years. DA's office, criminal defense attorney, 17, 18 years as a commissioner, both in Milwaukee and now in Waukesha. And I've not seen anything like this in my very long career.
I wanted to read the following article from Fox 6 Digital that was published shortly after the parade attack in 2021. In July 2020, Brooks was charged with a series of felonies after prosecutors say he fired a gun at his nephew outside a house on North 19th Street in Milwaukee. That is his mom's house. Brooks was ordered to have no contact with a number of people, including his mother, Dawn Woods, but when he was arrested again just a couple of weeks ago on new crimes, it was his mother who bailed him out. In early November 2021, Brooks was charged with 2 felonies and 3 misdemeanors, including second-degree recklessly endangering safety, after prosecutors say he ran over his girlfriend in a Milwaukee gas station parking lot. They are referring to Erica Patterson here. The incident left the mother of his child with a bloody face and tire tracks on her leg. According to prosecutors, he later tried to persuade the woman to not cooperate with investigators in exchange for marriage. In that 2020 shooting case, cash bond was set at $10,000 in July 2020, online court records show, but adjusted down to $7,500 in August 2020. In February 2021, 9 months before the Christmas parade attack, it was adjusted down again to $500. That $500 cash bond was posted in May 2021. Cash bond was set at $1,000 in that domestic violence case on November 5th, 2021. Brooks' mother posted the $1,000 bail in the domestic violence case on November 11th, 2021. But Brooks was not released from the custody of the Milwaukee County Sheriff's Office until at least November 16th, 2021. That's when he appeared before a Waukesha County judge, by phone, in the custody of the Waukesha County Sheriff's Department for failure to pay in a child support case. A judge released Brooks on his own recognizance in that case, just days before the parade attack, which led to outrage and renewed calls for bail reform. The low bail and the fact that Brooks was free after posting it before he allegedly killed 6 people and injured dozens of others in Waukesha led to outrage and renewed calls for bail reform. At the time of the Christmas parade attack, Brooks also had an active warrant out of Nevada for skipping court on sex crime charges. That again was from Fox 6. Here is some additional information that I found via Google searches. The person who approved the low bail for Darrell Brooks was not actually a judge. It was a court commissioner named Cedric Cornwall in Milwaukee County. After the attack, the Milwaukee District Attorney's Office admitted the $1,000 bail recommendation was inappropriately low and said it was a human error by a prosecutor. So basically, the DA's office also admitted fault for recommending such a low bail. They said the prosecutor handling the hearing overlooked Brooks's full criminal history. Court Commissioner Cedric Cornwall was indefinitely reassigned to non-criminal cases. Another factor is how bail works under Wisconsin law. Under the Wisconsin Constitution at the time, bail was mainly meant to ensure the defendant returns to court, not necessarily to prevent future danger. Judges had limited ability to set very high bail based purely on public safety concerns. That meant even someone with a long record might still get relatively low bail if the charge itself wasn't among the most severe categories, and prosecutors didn't argue for a higher amount. The Waukesha Christmas Parade attack sparked so much major political backlash that later Tony Evers signed changes to Wisconsin's bail laws, allowing judges to consider public safety more directly when setting bail. A group of residents tried to remove the local prosecutor. The complaint had legal deficiencies and was rejected. There was no action taken against the local prosecutor, John Chisholm. However, in January 2024, Chisholm announced he would not run for re-election after nearly 30 years as a prosecutor. His term ended in early 2025.
Thanks for watching, everyone. If you enjoyed this video, please do not forget to like and subscribe on your way out, and feel free to leave a comment. Have a blessed day.